Thank you so much for joining me and for the invitation to speak at the Privacy Week. Happy Privacy Week. I've missed it. I've missed you all. It's great to have this chance, and out of respect for you all, I've put on a suit and tie even though I'm in my own flat. It's 10 o'clock on Thursday night, and I've worked from home all day. So there you go. This is how seriously I take this. I thought I would just leave the lion's share of the time that we have available for a bit more of a dialogue. But I did have a few just sort of opening observations and comments I thought I'd share with you, because it's been a pretty wild time this last, gosh, now 3.5 years since I left to come and do this job. And remember that when I left, it was the middle of COVID. I got on that plane and thought, right, I can't get back into the country if something goes wrong. So it was quite a commitment, and I did sort of question, why am I doing this? And I have reminded myself, you know, in my 8 years as commissioner in New Zealand, we and the team achieved a heck of a lot. And I was really proud of what we achieved there. We were able to influence and guide government policy, tell people off, admonish and correct poor practice, and get real settlement for people, which is something that we don't do here, in fact. But outcomes for people who'd really suffered harms because of their interferences with privacy. And Michael and Liz and the team are all still continuing to do that, and I can see that from here. But there were times in the job you kind of feel a little bit like you hit a bit of a wall. You realize that you have sort of limited to no ability to influence the rollout of a new technology or the development of a new business model, or the terms on which New Zealand businesses and citizens are offered a personal information hungry product or service. So what really attracted me to the role of the UK Commissioner was an opportunity to influence corporate practice on a much larger scale in a way that could remove or reduce harm from or improve the lives of many millions of people. And with the UK being, the 6th largest economy in the world, freshly out of the EU and keen to differentiate, it seemed like a role that could really make a difference. And I think we have actually achieved some pretty impressive things, not all of which, or even many of which, I can claim credit for, because many of them were in train before I got here. But what I think has been most influential has been the work that we've done on keeping children safe online. I inherited the age-appropriate design code, which we call the Kids Code. It's directly led to a huge number of improvements in the safety of a number of the most popular platforms and digital services available to children. One of the largest platforms told me that as a result of the code and our work, they made more changes to their products than they did when the GDPR came in, and that's huge. So, the real differences that we've been able to achieve have been things like turning off geolocation for kids by default, which, really makes a tangible safety improvement for kids online. Setting posts that they make to private by default, blocking strangers from messaging kids, and even things like turning off notifications after bedtime. So it's actual real tangible things. I should say, by the way, that if you want to ask questions, please do drop them in the Q&A. And as soon as I've finished my rambling, I'll flip to that and we'll see what gets the most upvotes, what you want to know about, and take some time to talk through those. But I was thinking about your theme, which I think is an excellent theme, about being deliberate in how we go about our interventions, privacy on purpose. We have to be sort of deliberate and try and target our resources and our interventions to have the greatest impact. I mean, gosh, I don't want to say it because it's not bragging and I'm not down, dissing the OPC. But when I left, I think we had a budget of $5 million New Zealand dollars, which is about £2.5 million. My budget here next year will be £95 million. So we do have scale. But even with that, and 1,200 people working for me, even with that, sorry, I've just got a message there. All good. Um, we've got to make choices, right? Because a lot of our costs are fixed. A lot of our work is demand driven. So we've chosen to identify, and we did a similar thing in New Zealand, that to identify what is our discretionary capacity. To what extent can we set our own agenda? And so we've decided to prioritize three areas and for that discretionary capability. And in fact, not just the 10 million pounds or whatever that we can, carve off and set aside. It informs our decisions about how we work in our audit functions, in our investigations functions, in the policy work that we do, in the communications work that we do. And so we've settled on these three causes. And I won't talk too much about them, but we've decided that we prioritize for this year children online, as I mentioned, AI and biometrics, because it's like the topic of the year. It's everywhere. It's ubiquitous. There's a real rush to market, which means that there are risks and opportunities, and we need to stay ahead of those. And online tracking and advertising. And I won't talk too much about that, but we can come back if you want to draw stuff out of me from the in the chat. That's fine. Go to the Q&A. But we are, as I say, being deliberate about our choices. And that means not just what we do, but how we do it. So we have a range of ways of interacting with the community. It can be issuing guidance or setting out new policy positions. So last year, for example, we were able to consult on 5 different papers about some of the personal information implications of generative AI and how large language models are trained. So we've issued that guidance. We've settled on a policy position. Sometimes it means calling out a Home Office pilot on geotagging asylum seekers, which we did, which reminded me of some of the work that we did back at home. And sometimes it's issuing fines, which we have the capability for, which you don't have in New Zealand, which I was looking forward to when I came, I have to say. But it's not without its complexity, and it takes quite a lot of time. I've started to use the example that one of the first decisions I took in my job here in 2022 was to confirm a fine my predecessor proposed against Clearview AI, which is the biometric facial recognition matching service used by law enforcement authorities based on scraped images from around the web. So we issued a fine. Clearview appealed. They won on a quite surprising and pretty contentious issue. So we sought leave to appeal. It took the tribunal a year to respond to our request for an appeal. We've now got a date for that appeal. I'm 3.5 years into my term now. There is no chance that that matter will be determined before my term ends. So, people do talk about these big fines. You will have heard that Ireland fined TikTok €500 million for its data transfers to China. That's a very significant matter. We find TikTok. We'll be in court again on TikTok later next week. But, it'll take a year probably for a decision to come out. There may be appeals. There's almost certainly going to be appeals. So it just does take a long time. So be careful what you wish for. But they are tools that are important. We find a data processor, for example, advanced for failures in security. And these send really important messages, I think, into the economy. And of course, here we have quite big business, some organized crime, in fact, in sham telemarketing abuses, which breach our privacy and electronic communications regulations. And they target the elderly and the vulnerable. So we chase after them, we prosecute them, we issue fines on a pretty regular cycle, actually, for those. And that's really important. But I mentioned the work that we've done on young people. And what I think has been really edifying about that is that it does change the environment, not just for kids and young people in the UK, but right across the world. And the ICO does have a leadership role internationally. Just by virtue of its budget and size, it has a kind of heft. And I inherited that as well. My predecessor, Liz Denham, was the chair of the Global Privacy Assembly, as I had been as New Zealand Commissioner. But we do have a leadership role. And we started up, for example, the Adequate Countries Network, which is intended to better realize the potential of that, very laborious process of sort of bilateral allocations of adequacy status that the EU takes the fated few countries through. And Michael and Liz and the team are a really important part of that network. We're still part of the Global Privacy Assembly, of course, and other groupings like the OECD, but we also participate in G7 meetings, which is a much smaller group of influential data protection authorities which can develop and advocate for positions which can actually sort of lead to international standards. So it's pretty interesting stuff. And I mentioned AI. It is the topic of the day. We're never going to stop that technology, and we shouldn't even try. There are great benefits and efficiencies to be gained from it. So we've got to demonstrate how we take our principles-based legal framework and apply that to foundation models and large language model training. What are our expectations in terms of data minimization? Does that mean anything when you're training a model on all the data in the world? What does purpose limitation mean? How do you achieve transparency, explainability? How do you accommodate individual rights like rights in models? Some of these issues are still pretty contentious. We've set out our positions on them at the end of last year, which I think has been helpful for the sector. We had an intervention in 2023 with Snap, which was really interesting, actually, because in that heady time in the few months after ChatGPT launched, you remember it was the fastest app ever, 100 million users within about 2 months. Snap deployed a chatbot on its site that was accessible to very young users of that platform. And we were concerned that they hadn't met their obligations for risk assessment and accountability. And we issued a notice of intention to issue enforcement. As it happened, we didn't. They had an opportunity to respond. They were able to provide further documentation which showed us that they had, in fact, discharged their obligations to assess and mitigate risk. So, I think that was a really important lesson and some really important signals into the market. But again, one of the approaches that I took in New Zealand was the old adage that the single most important determinant of compliance with any regulation is ease of compliance. And I brought that over here as well. So, we make it easy through guidance, through our innovation advice service, which turns around, queries from industries about how to apply the law to new issues. We've got a sandbox, which is all the rage, which is a place where, you can bring these new issues and sort of workshop, stress test them and so on. And we've got this outfit, which I know is being emulated in New Zealand as well, called the Digital Regulators Cooperation Forum. And it set up a digital hub to advise industry of how to deal with issues that cut across, the digital economy across several remits of, competition and markets, the communications regulator, and the Financial Conduct Authority. So yeah, we're trying to make privacy easy. That was my motto back in New Zealand, and we have very much the similar philosophy here. The theme of Privacy Week this year, Privacy on Purpose, it actually resonated quite a lot with some of the stuff that we've been doing as well. Just thinking back over 40 years of data protection, we had our 40th anniversary. And part of the anniversary celebrations from our office included launching an exhibition that set out 40 objects that have shaped those 4 decades of privacy rights. And there's things like the poll tax. You can actually have a look at it on our website. Look up ico.org.uk. Have a look at the digital exhibition. We've got an in-person one in Manchester Public Library, but football ID cards, MPs expenses, COVID-19, all these disparate issues united by the value people place on their privacy and the noise they can make when that's placed under threat. But the common thread from all of that, I think, from those 40 items and other things, was the importance of trust, from the Human Genome Project to robotics and health tech. These products, these services, they weren't going to fly unless they took the public with them. And part of that, I think, is a respect for privacy and data protection. And the role of the regulator, the Office of the Privacy Commissioner in New Zealand, the ICO in the UK, is key to that. We are the proxies for people. And that's the same in New Zealand as it is here in the UK. So I could go on and on and on, and you know that I'm prone to. But I think what I'll do now is I'll tab back to the page and see what kind of questions we've got. Oh, there's a little red flag. We've got 10 there. Oh, I got some, there was some pre-questions too, wasn't there, which I should go through. Interested to hear about the Kids Code. Here in New Zealand, the social media ban for under 16s is being mooted. Based on your experience, do you think a code is more likely to be impactful than a ban? I am loath to intrude into the domestic politics of another country, these hotly debated issues. Australia's launched its ban, so we're all looking at that. And that's going to be fascinating the way that works out. I think one of the most sensible things I've heard on this subject came from a real advocate who's sometimes a pretty harsh critic of my office and me personally, and the role that we play in. She was really the author of the Kids Code in many ways. Baroness Bevan Kidron, a film director who's devoted her life to digital safety. But she was asked about this issue of a ban, and her view, I think, was really sensible. She said it's better to make these technologies safe for children than to try and ban them. And I think that's right. I was talking to the new chair of the Federal Trade Commission in the US a couple of weeks ago. And he's, of course, a Trump appointee and very much into keeping government out of people's lives, mostly. And, he was saying they are interested in children's privacy as well. It's really important to them. But they don't want government to be telling parents what their kids should or shouldn't be doing. They want to empower parents. And I said, look, brilliant, Andrew, I couldn't agree more. But the thing is, I wonder, we expect that parents will not give their children cigarettes, right? But we also make it a crime for retailers to sell children under 18 cigarettes. And I think there is an analogy. We have to insist that platforms who create products which are available to children, which they will be whether you ban them or not, to be honest, are going to be safe. And I think that there's plenty more potential there. And we've got more to do in giving effect to the code. But do I think the OPC needs more influence or authority here in New Zealand to give credence to the Privacy Act in light of the technology growth? I think the OPC in New Zealand has loads of influence and loads of authority, actually. And they use it. I used to think about this by using the term influence capital, right? If you're shouting at government all the time, you're not going to get anywhere. If you're picking up on everything and grouching about it, people stop listening. If you work alongside and help governments to achieve their objectives in ways that minimize the negative impact on individual rights, then when you do have to sit up and say something, they're much more likely to listen. But again, it's not for me to lecture Michael and his team. I think they're doing a great job. Fines aside, are there any other levers, legislative or otherwise, that you think are helpful in moderating organisational behaviour that we do not have here in New Zealand? Well, I think that the reforms that had just come in when I left, or been in for a wee while, but we were just sort of learning how to use them, of ordinance and compliance notices, have great potential. Making organizations do things is potential. Naming, publicizing the poor behavior and the good behavior, I think, is really useful. Guidance, as I say, is important. But again, when you've got limited resources, you've got to be very targeted about that. And there's no point reinventing the wheel. I wouldn't expect OPC in New Zealand to spend, to go out and buy a whole lot of AI expertise and reproduce guidance for training large language models, when most of them are trained outside the country anyway. And we've gone through that. The European Data Protection Authority's board has also issued guidance. So we are a community of international privacy people who share a lot of stuff and approaches and see eye to eye on a lot of things. How do we deal with organizations outside UK jurisdiction? It's tricky. I mean, we visit the big tech platforms in the States. Many have bases, if not in the UK, in Ireland, so they're sort of handy, and we deal through other regulators as well. But an organisation like Clearview, it has no base of operations in the UK. It doesn't sell its products into the UK. We've just issued notices. They have responded, so they've obviously been served with them. But we will engage with them. Sean Ritchie, hello. How can regulators establish and maintain the technical understanding needed to properly engage with emerging technologies? Is it possible or even necessary? I think it is possible, and I think it is necessary. You don't want to be the regulator measuring saddles when everyone's racing by in Lamborghinis. You've got to really, oh no, I'll keep talking in cliches just because it's you, Sean. You've got to be seeing where the puck's going, not just where it is. And you've got to be there. We can't be ignorant of these new technologies. I mean, AI is going to be part of the fabric of every kind of application that we use very soon, and people will be feeding personal data, personal information into AI apps. We've got to understand what the business models are, what the supply chains look like, what the risks are. We've got to be able to see through vendors' claims. And I worry in an economy like in New Zealand, where there are such cost pressures on government, there is a vulnerability to overhyped tools to be sold in to solve complex social problems, which may create more problems and may exacerbate existing kind of inequities. So we do have to be able to call bullshit sometimes, actually, which we've done, for example, on sort of purported emotion recognition. What do we call it? Emotion recognition software that some vendors were peddling to assist on in recruitment, AI recruitment. Congrats on the gig, thank you. What has been my most delightful and rewarding experience in the role? Gosh, there have been so many. I don't know. It's hard to pick just one. I mean, it's always great to be working with great people who are really, really get what privacy means to people and who are focused on protecting people from harm. We've got a great comms team. We had a campaign, a couple of campaigns actually. One was called Help Grand Stop Spam, and it built on the work that we did about these fly-by-night telemarketers who were harassing mostly elderly and vulnerable people into buying insurance products on whiteware. I don't think this scourge has come to New Zealand, but it really is toxic. And so it was a really nice example of bringing together the comms and the investigators and creating something that empowered people in the community as well as drew attention to our work. So it was really, really lovely. Check out our Ripple Effect campaign as well, in which we've tried to demonstrate that, when we talk about data breaches and we talk about gigabytes exfiltrated and language like that, we sometimes can forget the real impact on actual humans. So we have tried to humanize that. Lots of lovely familiar names popping up here, but I've just lost my track of it. Maya, hello Maya, kia ora. When thinking about generative AI, there's no putting this technology back in the box. Agree. So how would you approach striking that balance between regulation and innovation? Well, again, it's one of those. I'm a bit of a broken record when it comes to the false dichotomy. We've got to have both. And our job, or my job, I see as a regulator, is to show how you can innovate responsibly. We're doing that a lot with government. We're doing it a lot with industry. We are insisting on responsible innovation and calling out when we see innovation that hasn't hasn't given due consideration to the risks, as I mentioned with the Snap case. So we're down to the no endorsed. I'll better talk to Rick. All right, I'll do a couple more. Then there was some of you went to all the trouble to file questions in advance, so I better tab back to those. Stuart Daniel, what are your thoughts on simply banning social media for children? Is it a sledgehammer approach? We touched on that a bit earlier, Stuart. I don't know if you caught it, but I think I guess my I'm very interested in seeing how the experiment in Australia pans out. But here, the approach more generally has been to focus on making those products safe rather than trying to ban them. Rick, hello, Rick, how are you? If you look at the differences between NZ and the UK in terms of privacy protections, right of erasure, portability, fines, what do you think the most useful protection that UK individuals have that New Zealanders do not? Did we get explainability? I can't remember. I think that's really important and will become increasingly so. What else? Let me think on that one. You must have some thoughts, Rick, so drop them in the thing. Most upvoted. Right, I'm just going to tab back now before I take any more questions from the chat and go to the document that somebody's helpfully compiled. Someone asked me to comment on section 114 of the proposed UK Data Use and Access Bill, which, as you all know, eases the rules for charities to email prospective donors. This is something that businesses have. It's called the soft opt-in, not a hard opt-in. So it's a right to assume that if you've done business with them, you probably want to hear from them. And so charities wanted to have that ability to say, well, you gave us money to help ease the horrendous atrocities that are happening in Gaza last month. We think you're probably not going to object if we try and hit you up for that again this month, basically. Number 2, although New Zealand has maintained its adequacy status, what can you tell us about how New Zealand's privacy settings are viewed internationally? Do we stack up against much more rigorous jurisdictions with much tougher penalties, or are we falling behind in the eyes? I don't know how to tell you this. I don't know that New Zealand's privacy settings are viewed particularly closely. I have not ever heard anyone say, bloody hell, how did New Zealand get adequacy? Doesn't really happen. it's been really helpful for me actually, as we've been through a long process under the previous government. There was a more extensive law reform process, and we were getting very close scrutiny from the European Commission and some members of the European Parliament. And having my sort of detailed knowledge of New Zealand privacy law was quite helpful, because I was able to say that whatever the UK government does in terms of its proposed reforms, in terms of what was then on the table and what is now, at the end of it, the UK law will look more similar to the unamended GDPR than many other countries that the Commission has deemed adequate, including New Zealand. So that I think was helpful. But I mean, New Zealand is held in high regard, and I think there's still the very long tale of the reputation of particularly Blair Stewart, actually, internationally in driving many innovations, many regulatory innovations, and he's still somebody who is very highly regarded as a pioneer. He left the OPC in 2018 after, goodness, however many years that was. It was 25 years, I think. So yeah, the law and the office are highly regarded, I think, or at least that's what people tell me. What's been the most challenging, interesting part of moving to a regulator that also regulates freedom of information as well as privacy? It is fascinating. To be honest, I don't see very much of our FOI jurisdiction, because it's a fairly mature area of law, and there's a team of very experienced people who have built up a body of knowledge that allows them just to churn through them. They don't come to me and say, "Hey, which way are we going to go on this one?" Which is a shame in a way, because I quite enjoy doing those sorts of things. But they find their way through the tribunal as well. There's an appeal right, and which there isn't in New Zealand. So that's interesting. And we have transformed our freedom of information approach since I arrived, because we had a long backlog and huge delays, and we've absolutely turned that around and fixed it all. And I think there's more progress to be made there. But in terms of the substance, the most common quote I get when I'm talking about freedom of information is that attributed to Tony Blair, who said it was the biggest mistake he ever made introducing freedom of information. So it has a mixed reputation, but it is very highly valued by civil society, and I think by the Fourth Estate as well. And it's a well-used set of rights. Environmental concerns are very much front of mind here at the moment, and there is a specific environmental, freedom of information law. What about cultural perceptions of privacy? How do Brits feel about privacy compared to New Zealanders, and does this change the way they interact with the regulator? We don't sort of think about the cultural differences in the same way that we did in New Zealand. We don't have the similar. I mean, it's a very multicultural society, of course. But we don't have the same kinds of conversations about data sovereignty, and of course treaty rights that you have, and that must inform your kinds of governance and oversight. But there are different cultural approaches. I'm just trying to think of some. I met with members of the traveller community. There are, the nations have their own particular approaches. There are devolved health services and care services and the like in Wales, Northern Ireland, and in Scotland. And so differences do appear in some of those jurisdictions as well. The New Zealand Privacy Act has the requirement to have regard to cultural perspectives. Has he seen a similar requirement? Was that the same question? Sort of. Um, I do think so. Yeah, maybe that's slightly different questions. Maybe the cultural. There are a lot of people who complain in the UK. It's people talk about trains, the weather, and complaining is part of the daily conversation. And that flows through into our inbox as well. We get about 40,000 complaints a year, and some of them guess my email address, and I get to see just how outraged they are at the actions of the local horse fanciers society or whatever it is. Amazing how many similar experiences there are in that retail end of the business as there were in New Zealand. And I'll tell you one other thing actually that has really struck me, not just in the UK and in New Zealand, but while we all love talking about the shiny, the new, the AI, the biometrics, the nanotech, neurotechnology, and the rest of it, a really significant part of what people care about is access rights. We call them here subject access requests, your Privacy Principle 6 requests. And of those 40,000 complaints that come through our inbox, about half of those are access. And I think it's about the same proportions at OPC. And it happens all around the world. So what people really care about are those those individual rights that they are exercising themselves. And I think that's fascinating, that we mustn't neglect that. And I am trying to sort of think of ways of getting organizations to structure their record keeping in ways that sort of are more person-centric, so that it's not such a burden on them to exercise those rights, a burden either on the individual or on the organization. Cultural perspectives. Still we see still conversations about indigenous populations in Canada and the like, and those data sovereignty principles, but yeah, haven't been the same part of the conversation here. And there's the old classic, the ICO's enforcement jackets. We still have them. Apparently quite helpful for those chilly British mornings. Let me tab back to where are we? To the Zoom. Gosh, I've said Rick. I still haven't thought of anything useful, Rick, sorry. Anonymous, please explain more about your innovation advice service. Certainly. So we have sort of tiered, sorry, I might have mumbled that. There's a question, please explain more about your innovation advice service. When I was back in New Zealand, I had this hypothesis that people complain about how difficult the Privacy Act is and it gets in the way of things. And I thought, well, we could call that out and we could have this service offering of commissioners binding rulings. If you're worried about something, come and ask me what I think about it, and I'll put my money down. And so we created this policy and launched it, and I think we got about one. It's a similar idea here. The Innovation Advice Service says to businesses, if you're doing something new and you're not quite sure how the privacy, the data protection principles or articles will apply to it, you can set out your request, your conundrum, send it to us. We'll come back to you with an answer within 14 days. I think it's 14 days. And you can take that to the bank. So it's about trying to meet businesses who are keen to comply, trying to make it easy for them. I've always found it difficult to understand regulators who say, we can't talk about that in advance, or it might compromise our ability to look at it after the fact. I don't understand the difference between those. If you are going to apply resources to go around whacking people on the head after the fact, what you are doing when you do those investigations, you're saying you did X, the law says Y, the gap between X and Y is non-compliance, bam, I'm fining you. Well, what's to prevent us doing that ahead of time and saying our expectation with the the use of live facial recognition for crowd control in a football stadium is X. And if you do X, we'll say that probably meets the rules for proportionality and the like. So we've got our usual business advice lines that are running hot, often with registration complaints, because we are, of course, funded by every business in the UK. Gosh, I just about fell into the same trap I did in my first 6 months. I was giving a speech somewhere, and I kind of went blank for a moment, and I said, "And I'm going to make things better for every single person in New Zealand." And they kind of went, "You're in the United Kingdom." Anyway, so there are tiered responses. There's the regular phone line. We can escalate things up. Do you want innovation advice with that order? And then there's the sandbox, which is quite a formal. It's quite intense, so it's limited numbers. We only have about a dozen, I think, in the sandbox at any one time. But we've got capacity to answer innumerable questions in the Innovation Advice Service. And back to the other question, we will be, I think, before too long, using AI solutions to help with a lot of data protection queries, because why wouldn't we, right? I've got hundreds of people who answer those calls, and like we did in New Zealand with the Ask Us service, the FAQs, smart FAQs. AI can turbocharge that, and that means that we can release people to do higher value, greater impact work. Isn't it rather fatalistic to claim that generative AI can't be put back in the box? Surely if the social media experience of the last decade has taught us anything, it's that too credulously buying into the hype and treating platforms and their extraordinary data-hungry practices as inevitable has led to massive and avoidable harm, particularly to young people. Aren't you worried about the ability of regulators to keep up with and prevent similar harms? Yes, I am. Yes, I am worried about our ability. And I don't want the same thing to happen as has happened with search, the monetizing of and tracking of people, with cookies, and with social media. So this time we are not going to be left behind. We are going to be there, understanding the technology, setting out our expectations, and making sure that it is, that we don't get these harmful practices visited upon us by sleepwalking into them, which I think has happened with other technologies. Lovely to see you, John. Lovely to see you too, anonymous attendee. Curious as to how you are finding the privacy data protection in the UK. They often appear quite aggressive on LinkedIn. Oh, they do. I do. I live rent-free in quite a few heads, it seems. Look, it's a pluralistic community. There are strong views across a range of perspectives, and I really value that. I don't value the personal abuse, actually. I mean, there's one guy who's just obsessed. He's 90% chip and 10% shoulder. And you just block that out. But there are actually legitimate concerns about our regulatory approach, legitimate challenges from academics and other commentators. There's a quite strong thread of people whose business model would benefit from a different regulatory approach, and that's fine. They can advocate for that. There's also very strongly principled civil society groupings. And in that extent, I think just the size of the economy means the diversity of views and the strength of feeling is probably much higher here. But I actually do value even those who disagree with me. I think it's important. It's important to be challenged. And I go into the House of Lords and the Commons and get some pretty robust challenges there, and that's as it should be. I have to be accountable. These positions are for. Gihan, hello Gihan. Can you speak about limitations of privacy rules in regard to generative AI? For example, there is an EDPB decision that even where training data was collected in breach of privacy rules, providing it as anonymized subsequent use of algorithms is permitted, although where it is used to process now personal information, obviously privacy laws will then be engaged. Yeah, that's a quite a complex sentence, and I won't comment specifically on the EDPB, but the opening part, the limitations of privacy rules, is really interesting. There's a particular challenge, I think, in relation to, we did a consultation on correction, access and correction and erasure rights. And there's a debate. Some of the model makers say, well, our models don't contain personal data. It's all weightings and attributes. They're not personal data at all. I don't buy that. But they cannot accommodate correction requests except by writing new rules for how a model deals with a particular query or a particular individual. And that's something that is not scalable. So in that context, I think the solutions will be technological as well as the problems. But yeah, there are a number of challenges, and we're still finding them. And one of them, I think, is the concept we have here of controllership. Who is the data controller defines who is liable, who has the responsibilities. It's who is the, you would say who is the agency rather than the process. And just around the corner is agentic AI, where we are able to instruct AI agents to undertake tasks for us and make decisions about what data it needs in order to do that. And that, that's another set of challenges. But we will continue to try and keep pace with these and set out our expectations. What, in my opinion, are the biggest threats to public privacy currently, and what do you see as being the biggest issues in the next 10 years? There are so many. It's so hard. That guy who said predictions are very hard, especially about the future, he really had it. I think, I share Michael and Liz and team's concern about facial recognition. There's so many services now that I think are really dangerous. PimEyes, Clearview. I'm sure there's a bunch of other under the radar. What we saw with DeepSeek, for example, upending the economics of model development means that some of these really powerful tools are going to be available to the kinds of people who do the less responsible end of the market. So that's going to be tough. We've looked at things like neurotechnology, another Musk interest, and how to treat data that is generated through brainwaves, for example. Quantum computing. I see new predictions every couple of weeks about is it 5 minutes away? Is it 5 years away? Is it still decades away that we'll be having quantum computing disrupting all our expectations of online security and the like. So there's no end of things. We continue to be battered by cyber attacks here. That's a big problem. That's a very present problem, but it's exploiting legacy security vulnerabilities. So we've had Marks and Spencers and Co-op, another big chain, and even Harrods, I think, was hit. So continuing challenges. But the AI business, I do worry about overconfidence in the ability of some of these models to solve complex social problems, for example. And we've seen ideas on this in the UK, very similar to some of the ideas that we had to deal with in New Zealand from a public policy perspective. Kia ora, John. No, we did not get explainability. Thank you. Where are we? How is ICO approaching live facial recognition? Oh, I've got out of sync here. I don't want to miss out. on anyone. So I'm just going to go back up to. So that was biggest threats. Okay. Next one was this anonymous attendees got a lot of questions. Vis-a-vis intelligence organizations, how much regulation, control, and consultation do you and other OPCs do across the world? Really varied, actually. My colleagues in Europe often put their hands up and say, I have no mandate for intelligence and security. I spend a lot of time talking to people in the States at the Department of Justice, Office of National Intelligence, and Privacy and Civil Liberties Oversight Board, and they have a real role. I have a relationship with intelligence agencies, but only a limited sort of supervisory capacity here. So so the regulatory role, explicit regulatory role I have is about making sure telecommunications companies who comply with retention orders keep the information safe and secure and appropriately. But yeah, it's very varied in different jurisdictions. My German colleague has a explicit mandate, I think. I just said Europeans don't do it, but and they are currently engaged in a debate with their government because the suggestion is that they should lose that mandate. Hi, John, thanks for your time. While OPC continues to advocate for increased fines, it now seems that the best we can hope for are fines equivalent to those under the Fair Trading Act, which are mostly sub 1 million. I doubt this will change behaviour, but director liability might. Did you ever advocate for this in my time as commissioner? I can't remember. Someone will know. Drop it in the chat if I ever advocated for director liability. Colin Trotter, nice to see you. What is my relationship with law enforcement? What are the topical legal tensions at play there? Well, we work pretty closely with law enforcement. One of the big reports we released in my first year was about how law enforcement agencies, and the complexity here, Colin, is that there's, I don't know, 40 different police forces or something. And so there's a council of police chiefs, which is a sort of an entry point. We've got the Met in London, which is the biggest force by far. But they have a crisis of public trust at the moment. But yeah, we work closely with them. We supervise them. I was going to say one of the biggest reports we did was victims of rape and serious sexual offending and their experience. And I think you've done similar things in New Zealand. We called our report "Who's Under Investigation" because the victims' experience was that they felt that they were being re-victimized. Oh my gosh, I see the clock is running down. But yeah, and mobile phone extraction was a big part of that. So women having their whole phones extracted and being shown pictures of themselves and being asked to account for them. Outrageous stuff, really harmful, really humiliating. So we've come down on that. Live facial recognition, Colin, I think is going to be our next big thing. We had an issue with a database called the Gangs Matrix, which will be ringing bells with you, I imagine, and colleagues, because someone came up with the same idea in New Zealand. Do I see a universe in which FRT could possibly work in supermarkets while also being fair? How could FRT justify itself as worthwhile with the immense harm that came from staff trusting it in the Rotorua New World case? I don't know so much about the Rotorua New World case. I do think, the proportionality test is one, and the necessity test in New Zealand, isn't it? That's the hook, and we have to press these companies to justify. We took action against Serco, which also operates in New Zealand, doesn't it? They ran live facial recognition as a means for staff to clock in and out, and we in a dozen or so of their council-run leisure facilities around the UK, and we said that it was disproportionate, it was unlawful, and they stopped it. We didn't find them, I don't think. Thank you, Gary Bulog, who remembers everything. Tells me I did not look at director liability, but it's a good idea. Nice to hear challenging issues such as who's the controller. This is, oh no, sorry, I keep losing this thread. I think when you type in a new one, it sort of drops down. I see that I think I've got 5 minutes left. So what shall I pick up? We've done facial recognition. We've done a little bit about Maori perspectives. Have I picked up what can we learn from Maori? I do like to use proverbs. Hei tangata, hei tangata, hei tangata, for example. With your, yeah. Anyway, and I love going into the House of Lords and giving kia ora koutou katoa and getting blank stares back. But Keith Norris, an old stalwart of the direct marketing world, is use of name suppression service in UK mandatory before marketers send unsolicited offers. We have a telephone preference service, Keith. So, you can register your gran and if she gets a call from a marketer, we can actually prosecute them, and we do. And so they are obliged to wash their lists against that service. So it is mandatory. What is the UK equivalent function for NZ's GCPO, Government Chief Privacy Officer? Well, there's a Chief Digital Officer who's doing a lot of the heavy lifting on the sort of public service transformation. Paul Miller, hello, Paul. How big is employee browsing? It's hard to know, Paul. I haven't. We don't use that term. We do see inappropriate access. We do press for access controls, role-based access controls, as an important part of the armory. But yeah, I haven't really seen very much of that unauthorized employee access. We have prosecuted a few people actually for some things. We had a complaint. I think it was publicly. I better just check myself. Royalty being treated and details being shopped around to newspapers, I think became an issue in the press. I think that's something that was brought to our attention, shall I say. Challenging issues such as who is the controller. Sorry, my eyes are failing me at this late hour in my senior age. The Supreme Court recently released their decision in Tamafuna, confirming the police's collection of photographic intelligence without specific purpose constituted an unlawful search. Good on them. It now seems likely that the government might legislate in response to the ruling to allow police to continue this practice. What's my take? My take is the courts say what the law is, the politicians say what they think it should be, and that's how the world works. Oh, look, 2 minutes, 2 questions left. Can I do it? Eventually, if proportionality or necessity are not met, can individuals consent to the use of biometrics? I think there can be informed consent for the use of biometrics, but I mean, for example, I open my phone with my face all the time, and that's a biometric, and that's a consent. So yes is the answer. Thank you so much for the time to share. Gosh. Okay. Yes, the inappropriate access case was publicised. Thank you, Siobhan. Appreciate that. So nice to see all these familiar names. Shame I can't see your lovely faces. And thank you for your interest. It's been great checking in with you. I get back a couple of times a year, and I'd love to see you all. And yeah, look me up if you're back over this way. Thanks, everyone. Enjoy Privacy Week. Privacy for purposes, with a purpose, on purpose. See ya.